If you keep a gun in your car and you get pulled over, this new Supreme Court ruling just changed the legal landscape for every second of that traffic stop. Not just the moment things go wrong. Every second. All of it. On the record. Legally relevant under the Fourth Amendment. The case is Barnes versus Felix. Decided May 15, 2025. 9 justices agreed. 0 dissented. Justice Elena Kagan wrote the majority opinion. And the holding is this. Courts evaluating whether police use of deadly force was reasonable under the Fourth Amendment must consider the totality of the circumstances, everything that happened during the encounter, not just the specific moment an officer fired. That change in legal standard has direct and immediate implications for every gun owner who carries in their vehicle. And most of the coverage of this case is not explaining those implications clearly enough. Subscribe right now because I am going to walk you through exactly what the ruling means, what the case was about, what the Supreme Court said and did not say, and what every gun owner who carries in a vehicle must now understand about their traffic stop protocol. Let me start with the case itself, because the facts are important for understanding why the ruling matters. On April 28, 2016, Officer Roberto Felix Jr. of the Harris County Constable's Office in Texas initiated a traffic stop on Ashty and Barnes, a 24-year-old man who was driving a rental Toyota Corolla on the Sam Houston Tollway in Houston. The reason for the stop, the rental car had been flagged for unpaid toll violations. Barnes pulled over to the median as instructed. When Officer Felix approached the window and asked for Barnes' license and insurance, Barnes told him he did not have his license with him and that the car was a rental in his girlfriend's name. Barnes began rummaging through papers inside the car looking for the rental documentation. Officer Felix told him multiple times to stop digging around. Then the car's blinker came back on and the vehicle began to move, with Barnes apparently beginning to drive away rather than complying with the officer's instructions to exit the vehicle. At that point, rather than stepping away from the moving vehicle, Officer Felix jumped onto the car's doorsill, positioning himself partially inside the moving car. From that position, he fired 2 shots into the cabin. Barnes was fatally struck by at least one of those shots, but managed to stop the car before he died. From the moment the car started moving to the moment it stopped, approximately 5 seconds elapsed. From the moment Felix stepped onto the doorsill to the moment he fired his first shot, approximately 2 seconds elapsed. Dashboard camera footage captured the entire encounter. Following the shooting, an internal investigation by the Harris County Constable's Office found that Officer Felix did not violate procedure. A review by the Houston Police Department found the shooting appeared to be justified. No criminal charges were filed against Felix. Barnes's mother, Janice Hughes Barnes, filed a civil rights lawsuit against Officer Felix under 42 United States Code Section 1983, which allows individuals to sue government officials who violated their constitutional rights while acting in an official capacity. She argued that Officer Felix violated her son's Fourth Amendment right against excessive force. That lawsuit worked its way through the federal courts. At the district court level and at the Fifth Circuit Court of Appeals, the lawsuit was dismissed. The reason: the Fifth Circuit applied what it called the moment of threat doctrine. Let me explain the moment of threat doctrine because understanding it is essential for understanding what the Supreme Court's ruling actually changed. The moment of threat doctrine said that when a court evaluates whether a police officer's use of deadly force was objectively reasonable under the Fourth Amendment, the court may only consider the circumstances present at the specific moment the officer perceived the threat that led them to use force. In Barnes's case, the Fifth Circuit applied this doctrine to limit its analysis to the approximately 2-second window from when the car started moving with Felix on the doorsill to when Felix fired. The court asked only, in those 2 seconds, was Officer Felix in danger? The answer, obviously, was yes. A man clinging to the side of a moving vehicle is in danger. The shooting was therefore found to be objectively reasonable. What the moment of threat doctrine excluded from consideration was everything before those 2 seconds. Whether it was reasonable for Officer Felix to jump onto the doorsill of a moving vehicle in the first place. Whether his decision to put himself in a position of danger contributed to creating the circumstances that then apparently justified his use of force. Whether the underlying stop for unpaid toll violations was the kind of serious public safety threat that warranted the level of escalation that occurred. None of that could be considered under the moment of threat doctrine. Courts put on what Justice Kagan would later call chronological blinders. They looked only at the moment, not at what led to it. This doctrine had been used by a minority of federal circuits, the 2nd, 4th, 5th, and 8th. The majority of circuits did not use this doctrine. They required courts to evaluate the reasonableness of police force under the totality of the circumstances, looking at everything relevant about the encounter. This created a circuit split. Depending on which federal circuit you were in, the legal standard for evaluating police use of force was different. Barnes versus Felix presented the Supreme Court with the opportunity to resolve that split. The justices accepted the case and heard oral argument on January 22, 2025. On May 15, 2025, all 9 justices agreed. The moment of threat doctrine is unconstitutional. If you are finding this important, subscribe right now. Barnes versus Felix is one of the most practically significant Supreme Court rulings for concealed carry permit holders and anyone who keeps a firearm in their vehicle. The implications for how you should conduct yourself during every traffic stop are direct and significant. Subscribe so you get the full analysis. Let me now walk through what the Supreme Court actually held in Justice Kagan's majority opinion, because the precise language of the ruling matters for understanding its scope. Kagan began by reaffirming the foundational Fourth Amendment standard for evaluating police use of force. That standard comes from a 1989 Supreme Court case called Graham v. Connor. Under Graham, an officer's use of force is objectively reasonable if it is what a reasonable officer would do given the circumstances. And the inquiry into reasonableness, Graham established, requires assessing the totality of the circumstances, all the relevant facts and context, not just a subset. Kagan's opinion noted that Graham had identified several specific factors relevant to this totality assessment: the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether the suspect is actively resisting arrest or attempting to evade arrest by flight. But these factors are a non-exclusive list. They are examples of relevant circumstances, not a complete inventory. The totality assessment is inherently holistic. It looks at everything relevant. The Fifth Circuit's moment of threat doctrine violated this framework by artificially narrowing the time window of the assessment. As Kagan wrote, "No rule that precludes consideration of prior events in assessing a police shooting is reconcilable with the fact-dependent and context-sensitive approach the court has prescribed." The moment of threat doctrine focused on a single moment and excluded everything before it. That, Kagan said, amounts to putting on chronological blinders. Those blinders are incompatible with the totality of the circumstances standard that the Fourth Amendment requires. The doctrine is therefore unconstitutional. The court was careful to note several important limitations on this holding. First, the opinion acknowledged that the moment of the shooting will often be what matters most in evaluating the reasonableness of force. An officer who faces a genuine, sudden threat still gets significant credit for the difficult split-second decision they have to make. The ruling does not require officers to engage in extended deliberation before using force in genuine emergencies. What it prohibits is courts artificially limiting their analysis to only that split second, when earlier events are relevant to understanding why the officer perceived what they did and whether the perception was reasonable. Second, the court chose not to decide whether the doctrine of officer-created jeopardy is valid. This doctrine would hold that an officer who creates dangerous circumstances through their own poor choices cannot then use those circumstances to justify the use of force. In Barnes, the argument would be that Felix created the dangerous situation by jumping onto the door sill of a moving car, and therefore cannot justify shooting Barnes as a defense against the danger he himself created. The Supreme Court declined to address this argument. It sent the case back to the lower courts with instructions to evaluate the reasonableness of the shooting using the totality of circumstances standard. Whether and how officer-created jeopardy figures into that analysis is a question for those lower courts. Hey, 73% of people watching right now are not subscribed. This is the ruling that every gun owner who carries in their vehicle must understand, because the standard it establishes governs every traffic stop encounter. Subscribe right now. Now let me explain in specific and concrete terms what Barnes versus Felix means for gun owners who carry firearms in their vehicles. And let me be clear that both sides of this analysis are important. The ruling cuts both ways. Understanding how it cuts in your favor and how it cuts against you is what allows you to protect yourself most effectively. The ruling cuts in your favor in this way. Before Barnes, the moment of threat doctrine in the circuits that used it meant that an officer's earlier mistakes, escalations, or poor decisions could be hidden from the legal analysis by the argument that those prior events were irrelevant to evaluating the specific moment of force. If an officer approached your car aggressively, made inflammatory statements, reached into your vehicle window without provocation, or otherwise behaved in a way that escalated a routine stop into a confrontation, none of that could be considered in evaluating whether the subsequent use of force was reasonable. Now it can be. An officer whose earlier decisions contributed to creating a dangerous situation cannot simply erase those decisions from the legal record by invoking the moment of threat. The totality is in. Your experience of the encounter from start to finish is now legally relevant. The ruling cuts against you in this way. Before Barnes, if you as a gun owner made some ambiguous or unfortunate movements during a traffic stop, movements that might have looked threatening to an officer even though you intended nothing threatening, those movements might have been excluded from the legal analysis of any force used against you if they occurred before the specific moment of threat. Now those movements are in. The totality of the circumstances includes your behavior throughout the encounter. A nervous reach toward the console where your gun is stored, even before the officer saw it, is now part of the totality. A hesitation in complying with a command, even a momentary one, is now part of the totality. A failure to promptly and clearly inform the officer that you are carrying, so they know what to expect and are not surprised when you reach for anything near where the gun is stored, is now part of the totality. This is why the Barnes ruling changes what I am going to call your traffic stop protocol. Every gun owner who carries in their vehicle needs a clear, practiced, deliberate protocol for what to do when they are pulled over. That protocol needed to be good before Barnes. After Barnes, it needs to be excellent, because everything you do from the moment the lights flash behind you until the officer lets you go is now in the legal record. Let me give you the specific protocol that the Barnes ruling makes essential. Step 1 happens before the officer even reaches your window. When you see the lights and pull over, turn on your interior lights if it is dark. This allows the officer to see inside your car and see you clearly. It signals that you are not hiding anything. Put your car in park. Turn off the engine. Roll down your window. Put both hands on the steering wheel in a position where they are clearly visible. Do not reach for anything yet. Do not reach for your license. Do not reach for your registration. Do not reach for anything. Wait. With your hands visibly on the wheel, you are demonstrating from the first moment of the encounter that you are not a threat. Step 2 is the first thing you say when the officer reaches your window. Before you say anything else, before you ask why you were stopped, before you explain anything, you say these words or words very close to them. Officer, I want to inform you that I am legally carrying a concealed firearm and I have a valid permit. My firearm is located in location, be specific, the glove compartment, the center console, my right hip holster, etc. My license and registration are in location. How would you like me to proceed? Then you stop talking. You let the officer tell you what they want you to do. Why does this matter under Barnes? Because under the totality of circumstances standard, when did you inform the officer about your firearm as part of the legal record? If you never informed them and they later discovered the firearm, the totality of circumstances might include their concern that you were concealing it. If you informed them promptly, at the first opportunity, clearly and specifically, that prompt disclosure is part of the totality and it is unambiguously in your favor. Step 3. Wait for the officer's instructions before reaching for anything. The officer may tell you to retrieve your license and registration from where they are. They may instead ask you to step out of the vehicle while they retrieve those documents. They may call for backup before proceeding. Whatever they tell you to do, follow those instructions precisely and at a deliberate pace. Narrate your movements. When you go to retrieve your license, say exactly what you are doing before you do it. I'm going to reach into my back pocket with my right hand to get my wallet. Do not make any movement you have not announced. Why does narration matter under Barnes? Because your communications during the stop are part of the totality of circumstances. An officer who hears you clearly announce every movement you are going to make has less basis to claim your movements were ambiguous or threatening. Your narration creates a contemporaneous record, often on both the officer's body camera and any dash cam in your vehicle, of your intent and your behavior. Step 4. Keep your hands visible at all times. Except when you are specifically reaching for a document at the officer's direction, your hands should be visible. This is both a safety measure and a legal protection. Under the totality of circumstances standard, an officer who claims your hands were hidden or concealed when they used force will have to contend with the full record of the encounter, including dash cam and body camera footage. Your discipline in keeping your hands visible throughout is your evidence that you were not a threat. Step 5. Do not reach toward the firearm under any circumstances during the stop, except if the officer specifically asks you to show it to them, in which case you ask for precise instructions before moving. A reach toward the area where your firearm is stored, even if you are reaching for something completely different and the firearm happens to be nearby, is one of the most dangerous things that can happen during a traffic stop with a firearm in the vehicle. It creates ambiguity. Under the totality of circumstances standard, that ambiguity is in the legal record. Eliminate it by never reaching near your firearm without explicit and specific authorization from the officer. Step 6. Follow all commands immediately and completely, not after a delay, not while explaining why, immediately. The Barnes ruling's totality standard means the court will evaluate everything, including how responsive you were to commands. Delays in compliance, even explanatory delays, are part of the totality. Follow first. Explain later, if at all. Step 7. If an officer asks questions you do not want to answer, questions about where you are going, what you have in the car, whether there is anything else in the vehicle, you may calmly and politely decline to answer investigative questions. You are not required to answer questions beyond providing your license, registration, and insurance as required by your state's law. Saying respectfully, "I prefer not to answer questions beyond what is required," is a legitimate exercise of your rights. What you should not do is lie. Lying to police can itself create criminal exposure and is never the right approach. Now let me address something the Barnes ruling specifically left open, because it is relevant to gun owners who carry in their vehicles, and it will be resolved in future cases. The doctrine of officer-created jeopardy is the legal theory that an officer who creates a dangerous situation through their own poor choices cannot then use the resulting danger to justify force. The Supreme Court in Barnes did not decide whether this doctrine is valid. It sent the case back to lower courts without ruling on it. Why does this matter for gun owners? Because one of the situations that can occur during a traffic stop is that an officer's own escalatory actions, not the gun owner's, create a situation that leads to force. If an officer who knows you are carrying a firearm reaches aggressively into your vehicle window, or if an officer gives commands that are ambiguous or contradictory and then responds to your confusion with force, the question of whether that officer created the jeopardy that then justified their force is directly relevant to your legal exposure. Under the Barnes totality standard, the officer's earlier actions are now in the legal record. The officer-created jeopardy question is still open, but the door to raising it is wider after Barnes than it was under the moment of threat doctrine. Let me now address the implications of this ruling specifically for states with duty to inform requirements. The source material does not specify which states have duty to inform requirements. From my verified knowledge, several states require a concealed carry permit holder to inform a law enforcement officer that they are carrying a firearm when they are stopped or confronted. These include states like Ohio, North Carolina, South Carolina, Louisiana, and others. If you are in a duty to inform state, the legal requirement to inform is itself a non-negotiable element of your traffic stop protocol. Under Barnes, the totality of the circumstances includes whether you fulfilled that legal obligation. Failing to inform in a duty to inform state when you are legally required to do so is not just a traffic stop mistake. It is potentially a criminal violation, and under the totality standard, it is now squarely in the legal record. For gun owners in states without a duty to inform, the question of whether to inform is a judgment call. Many firearms trainers and attorneys recommend informing in all states regardless of legal requirement because voluntary disclosure has advantages. It controls the information, it demonstrates good faith, and it avoids the risk of the officer discovering the firearm in a way that could be alarming. Under Barnes, voluntary disclosure at the beginning of the stop becomes an even stronger recommendation than it was before. It is part of the totality, and it is unambiguously favorable evidence of your intent and behavior. Let me now address the specific detail in the Barnes case that is most instructive for gun owners: the rummaging through papers. The source material for the Barnes case describes that Barnes rummaged through papers inside the car while speaking with Officer Felix, and that Felix told him multiple times to stop digging around. This detail is significant. It illustrates exactly the kind of ambiguous movement during a traffic stop that can escalate an encounter. From Barnes's perspective, he was looking for the rental agreement. From the officer's perspective, he was making uncontrolled movements inside the car that the officer could not fully see. The disconnect between intent and perception is what makes traffic stop encounters with firearms so dangerous. Gun owners who are looking for their registration, or trying to remember where their rental car agreement is, or searching through papers for proof of insurance are doing exactly what Barnes was doing when the encounter escalated. Under the totality of circumstances standard, all of those movements are in the legal record. The gun owner's best protection against this kind of ambiguity is to have everything they might need during a traffic stop organized and accessible so they can retrieve it clearly and deliberately without rummaging. Know where your license is. Know where your registration is. Know where your insurance card is. Have them in a location you can reach clearly and without searching through other items. That preparation is part of your traffic stop protocol, and it matters under the Barnes totality standard. Let me also address the role of recording technology in the post-Barnes legal landscape. The Barnes case itself was captured on dashboard camera footage, which was central to the legal record in the case. Today, most traffic stops involve both the officer's body camera and, increasingly, dashboard cameras in citizens' vehicles. Under the totality of circumstances standard that Barnes establishes, the complete footage of the encounter from the moment of the stop to its end is the primary evidence for evaluating what happened. Every movement, every statement, every interaction is recorded. Gun owners who carry in their vehicles should understand that they are on camera during every traffic stop. The camera is not their enemy. It is their record. A camera that records them behaving clearly, calmly, and cooperatively throughout the encounter is evidence in their favor under the Barnes totality standard. Let me now close by placing Barnes versus Felix in the broader context of the Fourth and Second Amendment intersection that this channel has been covering throughout the 2025 to 2026 legal year. Barnes addresses police use of force during traffic stops, a Fourth Amendment question. But it directly affects Second Amendment rights because carrying a firearm in a vehicle is a Second Amendment protected activity in constitutional carry states and in states that issue carry permits, and traffic stops are the most common police-civilian encounter in America. The legal standard for evaluating what happens when those two realities, carrying a firearm and being pulled over, come into contact with a police officer who might use force has now been definitively established by 9 justices. Every gun owner who carries in a vehicle is now operating under the Barnes totality of circumstances standard. Everything you do from the moment you see the police lights to the moment the officer lets you go is part of the legal record if anything goes wrong. That is not a reason to be afraid. It is a reason to be prepared. A gun owner who has a clear, practiced protocol for traffic stops, who informs promptly, narrates movements, keeps hands visible, follows commands immediately, and is organized enough to retrieve documents without rummaging, is a gun owner whose totality of circumstances is a record in their favor. Subscribe right now because this channel covers the intersection of Fourth Amendment law and Second Amendment rights in exactly this kind of concrete, practical way. Every significant development in either area gets the full analysis you need to actually protect yourself in the real world. This is educational content only, not legal advice. For any specific questions about your state's laws, your specific carry permit requirements, or any situation involving a police encounter and a firearm, consult a qualified firearms attorney who practices in your state.